Domestic business person has always been fascinated about the idea of export of their product and tried to seek information from different sources. And today in this video, we will talk about export laws and procedure to export. Hello everyone, my name is Satyam Shivaach and I am an intern at LEXIS and Company. Private sector in India is expanding rapidly and because of it, different new products are being developed, manufactured and sold in the market. And in order for any company to increase its profit, they try to target audience from different nations. And in order to do so, they export their product to that nation. Export not only benefit individual business person, but also plays an extensive role in our nation's economy, as it provides us the increase of economic growth, the employment to people, and balance of payment. The Indian import and export system is governed by the Foreign Trade Development and Regulation Act of 1992, along with Indian Export-Import Policy. Most of import and export of all goods are free, except for the item regulated by the exempt policy or any other law currently in force. Registration with the regional licensing authority is a prerequisite requirement for the import and export of the goods. The custom will not allow for clearance of good unless importer has obtained an import-export code from the regional authority. Now let's talk about export policy. Goods can be exported freely if they are not mentioned in the classification of Indian Trade Classification. The ITC classifies the goods as restricted goods, prohibited goods, and state trading enterprises. Before exporting any restricted goods, the exporter must first obtain a license, explicitly permitting the exporter to do so. The restricted good must be exported through a set of procedure or conditions which are detailed in the license. The prohibited goods are the items which cannot be exported at all. The vast majority of these include wild animal and animal articles that may carry a risk of infection. Then there is state trading enterprises. In this, certain items can be exported only through designated state trading enterprises. The export of such item is subject to the condition specified in the exempt policy. Now while exporting, there are some duties of the exporters which are need to be followed. Let's see those duties. Start with the basic duty. The basic duty of the typical tax rate is applied to goods. The rates of custom goods are specified in the first and second schedule of the Custom Tariff Act. The first schedule contains rates of import duty. In the second schedule contains the rate of export duties. Most of the items in India are exempted from custom duty, which is generally levied on imports. Moreover, there are standard and preferential rates mentioned in the first schedule. Now, preferential rates are applied to goods which are specified by the central government, and the rest are applied standard rates. The IGST and compensation cess. Additional duties to custom, commonly referred to as the countervailing duty and special additional duty of custom, has been replaced by the levy of integrated goods and service tax, bearing a few exceptions such as pan masala and certain petroleum products. The IGST replaces the previous system of federal and state category of indirect taxations. Further, a few items such as altered water products, tobacco products, and motor vehicles, among others, will attract an additional levy of GST compensation cess over and above the IGST. This cess is calculated on the transaction value of the price at which the goods are sold. Now there is anti-dumping duty. This is levied on specific goods imported from specified country, including the US, to protect Indian industries. India can impose duties up to but not exceeding the margin of dumping, or the difference between the normal value and the export value. Now there is safeguard duty. A safeguard duty is a tariff designed to provide protection to domestic goods, favoring them over imported items. If the government determines that increased import of certain items are having a significantly determined effect on domestic competitors, it may opt to levy this duty on those imports to discourage their proliferation. Now there is Indian Free Trade Agreement. However, the duty does not apply to articles imported from developing country. The government may exempt import of any article from this duty. Followed by social welfare surcharge. The education cess in secondary and higher education cess was on imported goods is now abolished and replaced by social welfare surcharge. This surcharge will be levied at the rate of 10% of the aggregate duties of custom on the imported goods. Now valuation. The custom duty is payable as a percentage of value, which is known as assessable value or custom value. The value may be either value as defined in section 14 clause 1 of the Custom Act or tariff value, which is defined in section 14 clause 2 of the Custom Act. Then there is custom handling fees. The Indian government assesses a 1% custom handling fees on all imports in addition to the applied custom duties. Now let's see what are the export procedure. While processing an export order, the exporter have to follow the following procedure. Firstly, exporter must confirm the order. That is, the export on receiving the order must analyze the item specified, term of payment, delivery, etc. Then only he must enter into a formal contract with the overseas buyer. Then there is procurement of goods demanded by the buyer, followed by instance on quality control. Then he must lay down his emphasis on maintaining the quality specified by the foreign buyer. The next is finance for exporting goods. Now the exporters are eligible to obtain pre-shipment and post-shipment finance from the bank at reasonable interest to complete the transaction. Nowadays, packaging credit advance is given to the exporters. 70 to 80% advance is given, keeping the balance as margin. In the most shipment 180 days, the time period is given to the exporter for completing the transaction. Then there is labeling, packaging, packing and marking the goods to be exported. Then ensuring the goods to be exported. Marine insurance covers the risk of loss to the goods while the goods are transmitted to the buyer. In CIF, the exporter himself takes the insurance while in C&F, buyer takes the policy. Then the delivery of the goods are to be taken into consideration. The custom procedure of that country. The person can take help from the custom house agent of that nation. Then there is documentation for the process foreign trade policy, which has prescribed the following documents essential like airway bill, commercial invoices, shipping bill. Then there is submission of document to the bank after shipping the goods. It is mandatory for the exporter to present the certified document to the bank within 21 days of onward dispatch to the foreign bank for arranging the payment. The document should be include bill of exchange, letter of credit, invoice, packaging list, bill of landing inspection certified, declaration under foreign exchange and other necessary documents. The realization of the export proceed realizable in Indian currency and must be realized in 9 months. And then you will have to done with all the complete and successful export of good. Thank you.